Free speech in universities and K-12 schools is as critical as it is contentious. Ideally, educational settings are a marketplace of ideas. In this marketplace of ideas, even the most unpopular ideas should have space to be aired and tested. As in the most robust markets, it is this very inclusion of the unpopular, the contentious, that fuels the vigor and richness of the debate, empowering the discerning mind to debate, judge, and value the true merit of each perspective. In the recent and ongoing protests on college campuses across the country, it is not difficult to see protesters misrepresent free speech to justify violence and illegal behavior. We also see educational administrators use safety concerns as a pretext to justify censorship. And too many let their politics interfere with a principled defense of free speech. In this charged atmosphere, it falls upon educational administrators to hold the line of free speech. Upholding free speech is never easy, especially in tumultuous times. Now, more than ever, it's crucial that educational administrators exercise a principled defense of free speech. The First Amendment protects a wide range of speech and expressive conduct. However, it does not protect all speech and expressive conduct. Free speech does not imply that we can say whatever we want. There are boundaries. Only speech that falls within those boundaries is protected by the First Amendment. Those boundaries exist for good reasons. As university campuses grapple with students and faculty exercising their free speech rights with raw emotions, it's helpful for us to revisit the distinctions between protected speech and unprotected speech. In this video, I'll use legal precedents to provide practical guidance for educational administrators in their principled defense of free speech. Let's first begin with a fundamental principle. Violence is never protected by the First Amendment. This cornerstone of freedom supports the right to speak, to assemble, and to protest peacefully. However, it draws a clear line at the violence. Protests can be susceptible to sudden changes, such as the presence of opposing groups, police, and media. A lack of organizational plan can lead to disorganized and erratic behavior among participants. Individuals who incite violence can significantly destabilize protests, transforming them from peaceful assemblies to chaotic and potentially dangerous situations. Campus protests have the potential to and can escalate to violence, such as physically assaulting others or confining students within a specific area. Those behaviors cross the line from protected free speech into criminal activity. It is essential to understand that anyone who engages in violence during the protest should and often does face arrest and criminal prosecution. This is to ensure order and preserve free speech itself. The commitment to nonviolence must underpin every voice in protests. Let's remember, the power of idea is not enforced by fists or coercion, but by the strength and conviction with which they are expressed. The second boundary of free speech is set by true threats and intimidation. While the First Amendment protects freedom of speech, it also allows for restriction on true threats. What is a true threat? It is a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. Intimidation is a subset of true threats. To intimidate someone means making a statement directed at someone or a group with the intent of instilling fear of bodily harm or death. Importantly, the law does not require the speaker to actually intend to carry out the threat. A true threat is determined by the recipient's perception, not the speaker's intent. However, to prevent chilling protected speech, there must be a subjective mental state requirement. This means that the speaker's understanding of the threat is crucial. A recklessness standard where a person consciously disregards a significant risk that their words might harm another is the appropriate measure for true threats because it strikes a balance between safeguarding free speech and addressing genuine threats. In a Supreme Court case, Counterman v. Colorado 2023, the defendant, Billy Counterman, repeatedly contacted a person over Facebook in 2014, sending her creepy messages from numerous different accounts even after she repeatedly blocked him. Some of the messages implied that Counterman was watching her and saying that he wanted her to die or to be killed. She reported Counterman to law enforcement, who arrested him in 2016. Counterman was charged with stalking, serious emotional distress, and convicted in the lower court. But he appealed the decision, arguing that his communication were protected under the First Amendment because he did not intend to act on his threats. The key issue addressed by the Supreme Court was whether Counterman's statement constitute true threats despite his assertion that he had no intention of carrying out the violence implied in his messages. In its ruling, the Supreme Court sided with the state of Colorado, upholding the conviction. The Supreme Court emphasized that the legal definition of a true threat extends to statements where the speaker knows or should have known that the communication would be perceived as a genuine threat of violence, regardless of the speaker's actual intent to carry out the threat. The court clarified that the standard for judging whether a statement is a true threat is based on how a reasonable person would perceive the communication, considering context in which it was made. This reasonable person standard aims to balance the protection of free speech with the necessity of preventing genuine threats that can instill fear and disrupt public safety. Speech that crosses into threats of violence, especially when persistently directed at an individual in a manner likely to provoke fear and distress, does not receive First Amendment protection. The difficult part is that not all statements are clear-cut. We need to take context into consideration. To do so, I needed to introduce another term, incitement. Incitement refers to speech that is both directed to inciting or producing imminent lawless action, and it's likely to incite or produce such action. This definition comes from a landmark 1969 Supreme Court decision in Brandenburg v. Ohio. In this case, Clarence Brandenburg, a Ku Klux Klan leader in rural Ohio, invited a reporter to cover a KKK rally. At the rally, participants wore hoods and robes and burned crosses while Brandenburg made speeches condemning the government and advocating for revenge against Jews and Black people. He also announced a plan for a march in Washington, D.C. The state of Ohio arrested Brandenburg under its criminal syndicalism statute, which prohibited advocating violence for political reform and assembling any group for that purpose. Brandenburg was convicted, fined, and sentenced to prison. He appealed on the grounds that the law violated his First Amendment rights. In a unanimous decision that would redefine the boundaries of free speech, the U.S. Supreme Court overturned his conviction. The court clarified what constitutes incitement by introducing a two-pronged test. First, the speech must be directed to inciting or producing imminent lawless action. And second, it must be likely to achieve that outcome. The court reasoned the constitutional guarantees of free speech and the free press does not permit a state to forbid prescribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or producing such action. This means that the government cannot outright ban or prohibit speech that advocates for the use of force or encourages breaking the law. Free speech is generally safeguarded, but it can be restricted if it meets the two criteria of incitement, specifically if it directly encourages imminent lawless behavior and is likely to result in such behavior. This decision drew a sharp line between advocating abstract violence, which remains protected by the First Amendment, and actively preparing a group for imminent violent action, which is not protected speech. By overturning Brandenburg conviction, the Supreme Court protected his speech despite its offensive nature. This decision remains a key reference for understanding the limits of free speech in the United States. As we continue to witness debates over free speech across the nation, the Supreme Court's Brandenburg decision serves as a critical guide, ensuring that while our discourse may be fervent, it does not cross the line into actual cause for violence. Incitement must be directed toward causing imminent lawless action. It is not enough for speech to advocate for violence in the abstract. It must aim to produce immediate illegal activity. The speech must also be likely to incite or produce such action. This means there must be a reasonable expectation that the incitement will actually lead to illegal behavior. Consider a scenario on a college campus. Imagine a speaker at a rally passionately addressing a crowd. If this speaker exhorts the audience to commit an immediate attack on the passerby, this could very well cross the line into incitement. To determine whether speech is incitement or not, we need to look closely at the context. The key factors are the speaker's intent, the immediacy of the action encouraged, and the likelihood of the audience carrying out those actions. In our example here, if the speaker's words are directed towards producing immediate violence, and there is a real chance that those listening will act on those words, then the speech could lawfully be punished as incitement. This careful consideration is crucial, particularly in the chaotic atmosphere of a protest, where the line between heated rhetoric and incitement can sometimes blur. It is the responsibility of educational administrators to evaluate those situations closely, ensuring a balance between safeguarding free speech and maintaining campus safety. Discriminatory harassment is not considered protected speech under the First Amendment. Discriminatory harassment, especially in educational settings, is defined in Davis v. Monroe County Board of Education 1999 as behavior that is so severe, pervasive, and objectively offensive that so undermines and detracts from the victim's educational experience that the victim, students, are effectively denied equal access to an institution's resources and opportunities. This type of conduct goes beyond mere expression of ideas or offensive speech. It creates a hostile environment that impedes the educational process. The Supreme Court and other federal courts have consistently established that while a wide range of speech is protected, the First Amendment does not shield behaviors that constitute targeted harassment or discrimination. It directly harms individuals and breaches civil rights laws like Title IX and Title VI, which were specifically enacted to guarantee equal educational opportunities for all students. Discriminatory harassment, therefore, crosses the line from protected speech to actionable misconduct under federal law, warranting institutional intervention and legal accountability. Imagine a situation where students are denied access to attend classes or use the library. Those severe conditions not only disrupt the students' academic progress, but also strip away the very essence of a safe educational environment. When this level of harassment occurs, it demands institutional intervention. Colleges and universities are legally required to act against discriminatory harassment and ensure that all students have equal access to educational benefits and opportunities, free from barriers of harassment. Failure to address those issues does not just erode the quality of education, it constitutes a violation of federal law. One more thing, a commonly seen anti-free speech tactic is Heckler's veto. It occurs when individuals or groups disrupt or threaten violence at events, not merely to express disagreement, but to silence the speaker they oppose. The heckler's veto can effectively curtail a speaker's right to express their views. Instead of a dialogue or a peaceful protest, the event is overtaken by chaos. The speaker is silenced and the intended message is lost through intimidation or outright disruption. Legally, the heckler's veto is largely unsupported in courts because it fundamentally undermines the protections afforded by the First Amendment. The principle is clear. Government entities, including public universities and public K-12 schools, must not suppress a speaker merely to appease disruptors. To do so would grant veto power to those who shout the loudest or threaten the most, rather than safeguarding the democratic rights of the speaker and the audience eager to listen. As Justice Thurgood Marshall put it, the freedom to speak and the freedom to hear are inseparable. They are two sides of the same coin. On college campuses, bulletin boards are a common sight, serving as a central hub for students to share ideas, events, and messages. When posters or flyers lawfully posted in designated areas, like a campus bulletin board, are removed or destroyed without authorization, it is a form of the heckler's veto. This act silences the message intended to be conveyed, denying the speaker their right to free speech. Those actions are not protected by the First Amendment. In fact, defacing or destroy someone else's property to suppress their voice is a clear violation of the law. It is vandalism, and it is not protected by the First Amendment. The key issue with the heckler's veto is that it can be used to justify censorship on the grounds of maintaining order or preventing violence, which poses significant challenges to free speech rights. Addressing a heckler's veto effectively requires careful balancing between maintaining public order and protecting free speech, ensuring that neither is justly compromised. As we move forward, the goal must be to create educational environments where dialogue can thrive without fear, where the right to speak is protected as vigorously as the need to maintain a conducive, safe learning environment. In this video, I discuss the boundaries and the limits of free speech. Violence, true threats, incitement, discriminatory harassment, and heckler's veto are not protected by the First Amendment. In times of crisis and controversy, it can be tempting to bend the rules, perhaps tightening the restriction to prevent harmful speech or loosening them to avoid stifling free speech. However, it is consistency that marks an educational administrator as a principled defense of free speech. When free speech is selectively upheld, supported only when it aligns with the administrator's views, it erodes the very trust and credibility of educational institutions as forums for open dialogue and diverse viewpoints. This selective approach can lead to a campus where students and faculty feel censored, less inclined to engage in an honest exchange of ideas. Such an atmosphere not only stifles discussion, but also undermines the educational mission that thrives on diverse viewpoints. By shielding students from opinions that are at odds with administrators' views, schools do a disservice to their own mission. This selective censorship directly contravenes the spirit captured by Evelyn Beatrice Hall when she summarized Voltaire's belief. I disapprove of what you say, but I'll defend to death your right to say it.